Welcome to today's class. This is Ican Foundation course, and the diet is business law. The topic for today is the Nigeria legal system. At the end of this class, one should be able to answer these questions. What is law? Briefly explain the purpose of law. Identify the laws applicable in Nigeria. State and explain the forms of legislation in Nigeria. Differentiate between civil and criminal proceeding. Briefly explain the role of courts in the administration of justice. Identify the classification of courts. Explain the jurisdiction and composition of each court. Differentiate between criminal and civil law. Let's start with law. Oxford Dictionary defines law as a system of rules which a particular country or community recognizes as regulating the activities of its members and which it may enforce by the imposition of penalty. John Salmond defines it as the body of principles recognized and applied by the state in the administration of justice. Law is divided into three. That is, the definition of law is divided into three. We have law as a means of social control. Law is to serve the purposes of the society. Law, due to its nature, is coercive. That means it can be used to threaten, can be used for threat. Let's go to the sources of Nigeria law. That is where laws can be found. The first source of Nigeria law is the received English law. That is the common law of England, doctrine of equity, and statutes of general application. By the time we continue, we are going to look deep into this received English law. Now we also have law from Nigeria legislation, customary law, judicial precedents or case law, and international law. International laws are treaties, conventions, and protocols. Now we take us to the second source of Nigeria law, which is the secondary or subsidiary source of law, which includes law reports, law textbooks, learned works, law dictionaries, and journals. Now let's go back. As I told you before, we'll go back to what law is, the sources of law, and we'll go back to the English received law. And the first one there was what? Common law of England. Now let's go to that common law. I know about the common law. Common law is a body of unwritten laws based on legal precedents established by the courts. Common law was a law common to the whole of England. It was formed based on customs that were known to the people of England. Common law was introduced into England after the Norman conquest or in 1066. That is, the King's Court was set up by the first Norman king, who is King William the Conqueror. He appointed judges to handle these disputes. Now, these judges will go to major towns to decide important cases. With time, they returned to Westminster in London, and they discussed these laws and customs they had applied and the decisions they reached. As the time went by, the judges selected the best customs and applied it to cases that are similar throughout the country. It made the law uniform. But there was a problem with this. It was difficult to obtain justice from the courts because the common law was a rigid system. That is, actions were begun at common law through the issues of right. Now, what is right? Right is a written document issuing a legal order or a legal document issued by a court of law. Now, the lights available only covered a few cases. And what does that mean? Where there was no right, there was no remedy. And if there was an error in the right, the person who made the claim may lose that case. So common law courts could also give damages, that is ordering the defendant to pay a sum of money to the plaintiff as compensation. But where an injunction would have been more appropriate, like telling the defendant to leave a particular piece of property for another, the common law did not give room for that. So there were problems with the common law, and because of that, the doctrines of equity was put in place. Now, what do we mean by the doctrines of equity? The doctrines of equity means fairness, or whatever is just as ethical. Equity address the harshness of the common law system. If an aggrieved person could not obtain justice in the common law, that person is advised to appeal directly to the king. And most of these cases were referred to the king's chancellor, who was a lawyer, a priest, and the keeper of the king's conscience. The chancellor developed new remedies to compensate these claimants, that is the plaintiffs, more adequately. I believe that is understood. Let's continue. Let's go to equitable remedies. Now, there are many equitable remedies. We have injunction, specific performance, accounts of profits, rescission, rectification, equitable estoppel, constructive trust, subrogation, and many others. But we are going to dwell on just 4 of them in this course. So if I were you, I would learn these 4 and know them and know how to use them. Now, these equitable remedies, the first one is injunction. Injunction is an order to one of the parties in a case to do something or to refrain from a specific act. If defendant fails to comply, he faces criminal or civil penalties, which includes imprisonment or monetary sanctions. What is being said here? It said that in the court now, the defendant is told to stop from doing something, a particular thing that the person is doing, or to do a particular thing. We should take an example, which like a land case. A defendant might be told to leave the land and never go to the land, to stop building or to stop building on a particular piece of land. And if the defendant fails to comply, he's going to face criminal or civil penalties. Now, the second one is specific performance. Specific performance is an order that a contract should be carried out as agreed. Complete the contract that you are supposed to carry out. That takes us to rescission. Rescission is a remedy in contract cases to bring the parties as far as possible back to the positions they were before they entered the contract. That takes us to the last one, which is rectification. In this scenario, court orders a change in a written document to reflect what it ought to have said in the first place. This is to make sure that the content reflects their true intention. Now, apart from these four equitable remedies, there are some that have been developed recently, which we are also expected to know, because this development has to actually do with business itself. One is the freezing order, known as the Mareva injunction. What do we mean by the freezing order? Seizing a particular set of goods, making sure that those goods do not, or that particular person does not live that a particular place, or the goods do not leave a particular place at that particular time. Then we have the search order known as Anton Pillar order. Search order means giving the right to search a particular place or a particular goods brought into the country, or a particular goods at all. But now let us note something. If there's a conflict between common law and equity, equity always wins, because equity came to correct some rigidness, some mistakes of common law. Now that takes us to maxims of equity. What are the maxims of equity? What are the principles of equity? The first maxim is known as 1. Equity is equality. 2. Equity follows the law. 3. He who seeks equity must do equity. 4. He who comes to equity must come with a clean hand. You cannot come for fairness and it shows that or you are now proved wrong. 5. Equity will not suffer a wrong to be without a remedy. That means every wrong, there must be a solution to every problem. 6. Where the equity are equal, the first in time prevails. 7. Delay defeats equity. 8. Equity looks at substance, not at form. 9. Equity imputes an intention to fulfill an obligation. 10. Where the equities are equal, the law prevails. 11. Equity looks on that as done what ought to be done. And the last one, equity acts in personam, that is against the person. I believe that is understood. Now that will make us move to the next source of Nigerian law, which is the Nigerian legislation. Nigerian legislation includes, first, the Constitution. When we say the Constitution, what do we mean? The Constitution is the supreme law of the Federal Republic of Nigeria, and any law that contradicts the Constitution is null, void, and of no effect. Now, what are the characteristics of the Constitution? What are the characteristics of Nigeria Constitution? 1. Supremacy. Nigeria Constitution is supremacy and is binding on everyone living in Nigeria. If any law made is not in line with the Constitution, that law is null and void and of no effect. Writing and rigidity. The Constitution of the Federal Republic of Nigeria is written, and it makes it very difficult to amend. It can only be amended by 2/3 majority of the National Assembly, supported by at least 2/3 majority of the State House of Assembly. That takes us to federalism. The Constitution divides the power of the government between the federal and the states of the federation. The exclusive legislative list of the Constitution matters are legislated solely by the federal government. The exclusive legislative list of the Constitution matters are legislated solely by the federal government. That means the federal government has right, the National House of Assembly has rights solely to the exclusive legislative list, while the federal and the state government legislate on matters on concurrent legislative lists. And if the Federal Act and the state laws contradict on a subject, the Federal Act prevails. Federal laws are also called acts, while state laws are called laws. Now there is one we will also add, which is the residual legislative list. Residual legislative list. This is solely for the state government. The federal government has nothing to do with legislative and the residual legislative list. In case you are asked how is the legislative powers divided between the federal and the state government, you know that exclusive legislative list is mainly for the federal government. The concurrent legislative list is for the federal and the state government, while the residual legislative list is solely for the state government. And that being said, let's go to the next one, which is separation of powers. Remember, we're still talking about the characteristics of Nigeria Constitution. Separation of powers. Now, the Constitution separates powers of the government to act as checks and balances on each other. Now, these powers are divided into three. We have the executive, we have the legislature, and we have the judicial branch. These branches, or these parts of these separated powers, act as checks and balances to each other. While we go on, I will show you how it acts as checks and balances. Now, we also have the rule of law. The rule of law. I hope I am not being too fast. If I'm being too fast, you can go back and listen again. And if you do not understand, you can always send questions to us. We will always be there to answer you, or to answer your questions. If anyone is confusing, draw our attention to it. We will come and answer you. That is our job. Now let's go to the rule of law. The rule of law, which is the principles of the rule of law, has two aspects. We have the nemo judex in casua sasua, that is, a person cannot be the judge of his own case. And then we have all the alteram partem, that is, a person shall not be condemned without hearing. Those are the rule of law. Now that takes us to fundamental human rights, which I believe is the last one. This includes right to life, right to dignity of human person, right to personal liberty, right to fair hearing, right to private and family life, right to freedom of thought, conscience and religion, right to freedom of expression and the press, right to peaceful assembly and association, right to freedom of movement, right to freedom against discrimination. If any of these rights is infringed on, the person can approach the state high court and the federal high court for redress under the fundamental rights enforcement procedure rules. That takes us to acts. What are acts? Acts are laws passed by the National Assembly in a democratic government. I had said that before. National Assembly, that is the federal government, laws passed by them are called acts, while decrees are enactments made by the federal military government during a military regime. Laws are made by the House of Assembly of a state in a democratic government. Edicts are laws made by the military government of a state during a military regime, while bylaws are laws made by the local government council. I believe that is understood. That will take us to customary law. Customary laws are laws that are seen as binding in a particular community. They include ethnic customary laws, which are applied to a particular ethnic group or community. For example, people who do there is this thing we call in Nigeria akawo. There are laws guiding it, there are laws binding it. They are called customary laws. While in the north, there is another called Islamic customary law, which binds members of the Islamic faith. Now, there are just two customary laws. We have the ethnic customary laws, and then we have the Islamic customary laws. The ethnic customary laws bind a certain group or community, while the Islamic customary laws bind members of the Islamic faith. Now, let's go to characteristics of customary laws. 1. It is largely unwritten. Customary laws are largely unwritten except Islamic laws. 2. It is considered binding on the members of the community or group. That is mirror of accepted usage. It is seen as a mirror of accepted usage. Everybody agrees to it. Everyone accepts it. So it's binding on the members of a community or group. 3. Establishment is by proof through assessors or authoritative books when it has not been used by the courts. That is, people, assessors or books written to be used as the customary law is a proof, is what the members can use as proofs. And then the last one is it is largely flexible. It can change, you can work on it, you can turn it. It's flexible, it can be changed at any time. Then how do we validate customary law? How can customary law be validated in a court of law? Now, it has to face through 3 processes before customs can be regarded as a law. The first one is the repugnancy test. That means it must not be barbaric or fall under civilized standard of behavior. It must not be distasteful or unacceptable to natural justice, equity, or good conscience. For example, the Igbo tradition has this law that if a man does not pay a woman's bride price and the woman gets pregnant or falls pregnant, the child does not belong to the man. Now, the rule of law will stand against it because it faces the repugnancy test. It does not pass that repugnancy test. It is distasteful, it is unacceptable, it is not equitable. Now we have the incompatibility test. That is, no customary law should contradict an existing law. No customary law should contradict an existing law. Then we have the public policy test. A customary law must not be contrary to public policy. Example is trying to make illegitimate children got out of marriage to be legitimate. It will encourage promiscuity, and so it fails the public policy test, which makes that particular law not acceptable. Now, what are the proofs of customary law? What are the proofs of customary law? The first proof is direct oral evidence. Direct oral evidence, like calling people elders and custodians of native laws or native laws. Yes, custodians of native laws. The second one is documentary evidence, like presenting as evidence research findings of experts, books, manuscripts in the custom intended to be proved. The third one is judicial notice. Judicial notice. This shows that a court of high authority or coordinate court had accepted it. That takes us to judicial precedent or case laws. Judicial precedent or case laws. Judicial precedent is a decision made by a court that shows a principle of law. They are decisions made by a court to establish a principle of law. It is an application of stare decisive. And stare decisive translates stand by what has been decided and do not unsettle the established. This means that the lower courts are bound to follow the decisions of the superior courts if the case is similar. A precedent is constituted through the material facts plus decisions thereon, that is ratio descendendi. Obi dictem is the remainder of a past decision which does not constitute a precedent and which need not be followed. Now, what is obi dictem? Obi dictem is that a judge expresses expression of an opinion uttered in court or in a written document, that is obi dictum or obi dicta. Obi dicta, that is an expression of a judge's opinion uttered in court or written in a document. Now let's go to types of precedent. We have the original precedent, that is a case that has not been tried before. Then we have the binding precedent, which is a decision made by a superior court that a lower court is bound to because the facts are similar. Then we have persuasive precedent. This can arise from sources such as obi dicta. Okay, we have given you the meaning of obi dicta, which is also the same thing as obiter dictum. Obiter dicta and obiter dictum. Dissenting judgments and decisions if caught in other common law jurisdiction or other countries. I hope you understand. That is, persuasive precedent can arise from sources such as obiter dicta, dissenting judgments and decisions if courts in other common law jurisdiction or from courts in other common law jurisdiction or countries. They are not binding but persuasive, especially between two courts of coordinate jurisdiction. That takes us to terminologies in precedent. Terminologies in precedent. We have distinguishing. We have some terminologies that we use in precedent. We don't just use anyhow words or anyhow languages. We have distinguishing. That is, a judge adopts this method to avoid following a past decision. The judge claims to find the facts of a case materially and sufficiently different from a previous precedent. That is distinguishing. Then we have overruling. Overruling is the nullification of a previous decision by a Supreme Court, the same court or a statute, and a formation of a new rule. Then we have reversing. Reversing is when a higher court overturns the decision of a lower court on appeal in the same case. We have perincurium. That is, a decision made in error or mistake is overruled. This can happen in the Supreme Court. When a decision is made in error or mistake, it is overruled. Now, what are the advantages of judicial precedent? We have three advantages of judicial precedent. We have the certainty, that is, it makes law certain. We have consistency, it makes law consistent and fair. Then it saves time in court. It's a time saver. Now, disadvantages. Everything that has advantage should also have a disadvantage. Disadvantages of judicial precedent, that is, laws are rigid and mechanical. Secondly, it may lead to loss of initiative. That is, the judges will no longer they will no longer be able to use their initiative in cases because they believe those cases have been handled before. It can lead to illogical distinctions. When we say illogical distinctions, what do we mean? That is distinctions, that is the judge is trying to distinguish cases that are similar so that they can actually judge that case, to judge that case how they actually want to judge that particular case. Then there's difficulty in finding the relevant case law and distinguishing the ratio of a case from the obiter dictum. We also have slow development of the legal system because of the judicial precedent. Two essential conditions must be satisfied for an effective operation of the doctrines of precedent. And these essential conditions are a settled and good hierarchy of courts and a good law reporting system. That being understood, it will take us to classification of courts. Now we have two classification of courts. We have the courts of records and courts other than courts of records, and then we have the superior courts and the inferior courts. Let's start with courts of record and courts other than courts of records. Courts of records keep records of all their proceedings and are powered to punish for contempt of court within and outside the court. While courts other than court of records does not keep records of their proceedings and can only punish contempt within the courts. I believe that is quite very clear. Then we have superior courts and inferior courts. Superior courts, we have superior courts as Supreme Court, Federal High Court, the High Court of the Federal Capital Territory, the State High Courts, and other high courts. Then the inferior court, we have the Magistrate Court, District Court, Area Court, Juvenile Court. Let's go to hierarchy of courts. Remember, a good system should have a good hierarchy of courts. The highest court in the the Federation of Nigeria is the Supreme Court. The Supreme Court has the highest and the final decision that binds all other court precedents. Now, the Supreme Court can only deviate from its previous decision if the previous decision was reached per incuriam. When we say per incuriam, what do we mean? Probably if it was reached by mistake or they did not get the correct or the complete file when that decision was reached, or if there are two conflicting past decisions in which the court has to overrule one. That takes us to Court of Appeal. Now, Court of Appeal is only bound by the decision of the Supreme Court and its previous decision, except it makes a mistake or there are two conflicting past decisions in which the court has to overrule one. That takes us to Federal High Court. Federal High Court is known before as Federal Revenue Court, but it was changed to Federal High Court in 1976. It was established in 1973 and renamed in 1976. It has the exclusive jurisdiction in all matters that has to do with the following: revenue of the government of the Federation, the taxation of companies and persons that are subject to federal taxation, customs and excise duties, banking, banks and other financial institutions and anything that has to do with financial institutions, any admiralty matter, diplomatic, consular and trade representation, citizenship, naturalization, extradition, passports and visa, bankruptcy and insolvency, aviation and safety of aircrafts, arms, ammunition and explosives, drugs and poisons, weight and measures, administration, management and control of the federal government or any of its agencies, treason, setting statutes on certain matters conferred by the EFCC Act, ICPC Act and NDLEA Act. That takes us to State High Court. State High Court has jurisdiction in civil and criminal cases, and the court has power to impose any punishment up to death as the case may be. Then we have the Sharia Court of Appeal. This Court of Appeal exercises appellate and supervisory jurisdiction in civil proceedings that involve questions on Islamic personal law coming from area courts of appeal. The next one is Customary Court of Appeal. This court has precedent on inheritance and marriages in any state that requires it. Now we are going to National Industrial Court, which is one of the inferior courts. We have National Industrial Court. Then this National Industrial Court proceeds on labor and industrial relations disputes. Let's note that the Federal High Court, State High Court and National Industrial Court and Customary Court of Appeal and Sharia Court of Appeal are courts of coordinate jurisdiction. Decisions of courts outside Nigeria does not constitute a binding precedent on any Nigerian court, but are persuasive precedents. Now let's go to the secondary, or what do we call them? Secondary or inferior courts. We have the magistrate or district courts. These courts must follow the principle of natural justice. That is, the magistrate courts are found in the south, while the district courts are found in the north. Then we have the customary courts and area courts. These courts handle essential matters of customary courts. Customary courts are found in the south, and area courts are found in the north. Each customary court may be composed of a president and at least 2 or 3 members, as the case may be. Also, the Judicial Service Commission can appoint, dismiss, and express disciplinary control on the members of the customary court. Now, let's note that a customary court in Lagos has civil jurisdiction over matrimonial causes in relation to marriage contracted under customary law. The court's criminal jurisdiction includes contempt of court committed in the face of the court, offences against the rule and bylaws made by a local government council, and any offence against the provision of an enactment which expressly conferred jurisdiction in the court. That will take us to international law. These are multilateral and bilateral treaties, conventions, as well as global and international charters. They form part of the Nigerian law once the National Assembly passes an enabling statute to the effect. That will take us to legislative process. Now, legislative process is a process of democratic government that begins with the introduction of a bill to one of the 2 houses of the National Assembly, or if the House of the National Assembly or the House of Assembly of a state. Now, legislative process is when a bill is introduced to any of the 2 houses of the National Assembly or the House of the Assembly of a state. Now, this bill, what is a bill? A bill is a proposal that is intended to become law if passed. Any proposal that is intended to become law, if passed, is a bill. That takes us to types of bills. A type of bill, we have two types of bill. We have the public bills, that is bills that affect the interest of the public, or private bills, bills that affect a particular group, locality, region, or profession. These are called private bills. Let's quickly move to stages of bills. What are the stages of bills? A bill must pass through some phases before it can be called a law or act. The first phase is first reading. That is where the bill will be presented and the House will vote to decide if that bill should be considered or not. If the House decides that the bill should not be considered, it's thrown to the dustbin. But if the House now says, this bill, let's consider it, let's see if we can change it to, let's see if it is worthy to become law, it is now moved to the next stage, which is the second reading. The second reading, that is after the first reading, is the House now debates on the principles behind the bill. Why was this bill brought here? What are the principles behind this bill? After debating on it, they cast another vote, the House casts another vote and decide if they should actually support the bill or not. Now, in the first reading, there is no argument, but in the second reading, there is argument, and there must be a majority vote for for the bill to move ahead. When the votes are casted and the bill is accepted after the second reading, it moves to the third stage, which is the committee stage. Here, the committee stage, a selected committee is made to critically examine the bill and each clause of that bill. Examine the bill and each clause of the bill. But there is an exception. If it has to do with anything financed bill, the whole House must sit in the committee. The whole House must be involved. Now, after the committee has had examined that bill, after they had examined the clauses in the bill, it moves to the next stage, that is the report stage. The committee reports back to the House on amendments they made, and if there is need for further amendment before the bill goes to the next level, the House does the amendment, and then it goes to the next level, which is the third reading. It's just a formality stage where if certain members of the House insist that the bill should go through a third reading, it will just go through a third reading, a final look will be made on the bill, and then a final vote cast. After that, it goes to the last level, which is the president's assent. President's assent, that is, the president is required to sign the bill so that it will be passed into act. But if it is a state, the governor is required to sign so that it will be passed into law. If the president or the governor refuses to do that refuses to do that after 30 days, that is, he is trying to exercise his veto powers because he believes that the bill should not be law. The House can overturn this veto power by two-thirds of the members, the third of the two houses of the National Assembly voting for the bill. If two-thirds of the two houses of the National Assembly vote for the bill, this will make it make it an act or make it a law. This also happens in the House of Assembly. Now let's go to the distinction between criminal and civil laws, or criminal and civil case, as the case may be. Now, criminal law creates offenses that are punishable by statutes, but civil laws guards the rights and interests of citizens in interpersonal relationship. Criminal law punishes the offender by imprisonment or imposition of fine, or both imprisonment and imposition of fine, while civil law compensates the injured or aggrieved party. Criminal law is a standard proof is proof beyond reasonable doubt, while civil law standard proof is preponderance of evidence or balance of probabilities. The defendants could be prosecuted for offences at any time when it has to do with criminal law, while in civil law there is a statute limitation. That is, the plaintiff must institute an action against the defendant within 6 or 12 years. The decision to prosecute a person in criminal law is taken by the state on behalf of a person, while the decision to sue in civil case is to be made by the injured or aggrieved person. Pardon the triple aggrieved. Now, the person in criminal law is found guilty, convicted, and sentenced to custodial or non-custodial punishment, while the defendant is going to be liable and made to pay damages and compensations to the aggrieved or injured person, or is subjected to equitable orders as injunction or specific performance. The parties are the plaintiff and the defendant in a civil law, while in a criminal law the parties are the state and the accused or the defendant. I believe we have come to the end of the class. If you do not understand anyone, draw our attention to it, and when we come to you, we will try to explain it better to you. Okay? That being that, this is the end of the class.